you have raised to several state entities, like Vishwabharati, and Malat. Now the issue before your lordship is they have given us a so-cause notice, a so-cause notice on the premise that you should have you are under the you should have raised invoices with the service tax and you are under the amenable to the service tax regime. There's one of the notifications, which I'll point out before your lordships, where the notification specifically states that we are entitled to be exempted from the GST regime. They refer to one more notification in that. That is from Patna, that is from Bihar, which is before your lordship. Now, the impression, why I say the impression which was created,
the determination has been made.
Yes, we are before the. Well, I'm being led by Mr. Park.
Please, Your Lordship.
Determination has been made.
The show cause notice order has been passed. But I'll indicate that the show cause notice itself is not maintainable. But that's one point by which, my lord, I have a case before your lordship because this becomes without jurisdiction.
Mr. Bagh, difficulties. You are saying that you may be exempted.
No, I'm not, my lord, I'm not saying that.
He said so. Your junior said
he's right. He's right. That we are exempted.
What your junior said, you are disclaiming.
No, absolutely not. He's absolutely prepared in the matter.
That you may be exempted,
my lord,
which has not been considered.
No,
right, wrong, and decision has been taken. Why will this court, in exercise of its Article 226, usurp the jurisdiction of the appellate authority?
Very, very grateful. It's not usurping, first of all, my lord, it's not usurping the jurisdiction at all. My lord, today, if the show cause notice is without jurisdiction, the entire proceeding becomes bad in law. I'll show, my lord.
Refer an appeal. Appellate authority will consider that.
That's also one of the grounds, my lord, by which I can approach this honorable court, because there are judgments which, my lord, are on the point. I'm only restricting it to 2 points, my lord. One,
this is service tax.
Section, my lord, it's service tax. Extended period of limitation is what is not availed of.
Now, after the service tax, you see today, these are all appealable under the GST.
It is, my lord. It is.
Under section 85 itself.
Same. Central excise.
Under section 85. Prefer an appeal under section.
I don't need to. I'll indicate why. Kindly hear me for 5 minutes. Yes. I'll try and convince your lordship that I do not, my lord, need to be relegated to the appellate authority route.
Not relegated. Why will this court take up this matter?
I'm grateful.
Delegate is something else. That you don't have this. You don't have enough material.
No,
and as such, this court will say go before the appellatory. Not that. Ordinary courts is to approach the appellate authority. Extraordinary courts is to approach this court. Why will this court hear you on
this? Because it is an extraordinary set of facts.
Show me.
I'll indicate. Lord, what is the case? Before I request your lordship to look into the papers, I'll indicate very briefly what the case is. Lord, we had provided service under certain heads. Lord, while providing the service, chunk of the service was provided to, my lord, government entities. They have always made it clear that service tax was not applicable in these set of facts. Hence, my lord, from the bills and invoices, I'll show that, my lord, this component was always missing. And these components, my lord, are not components made by us. It's made by those, my lord, government entities who, my lord, raised this invoices. So according to their understanding, the service tax component should not have been levied. My lord, we have filed ST3 returns all throughout. My lord, we have not availed of any, my lord, benefit under the ITC, which we were not, my lord, entitled to. What we have done here is, my lord, on the basis of 2 exemption notifications, which we have taken advantage of, we have said that this part is exempted. While this part is exempted, my lord, there is a time frame for them to initiate a proceeding against us. That time frame, my lord, can be exceeded only if, my lord, 3 ingredients are satisfied. Suppression, which has to be willful, and, my lord, an intent which has to be shown by them that it is to evade tax. The only point which they have taken is, my lord, the exemption notification. We say the exemption notification is applicable. They say it is not applicable. That's the case before your lordship. So, my lord, today my case is they could not have issued the show cause notice at the first instance. And I'll not trouble your lordship with the merits. Not for once, my lord. That I know, my lord. If I'm relegated, if I have to go before the appellate authority, that was the point I would have taken. My point today before your lordship is that the show cause notice could not have been issued at all. And why I say so, my lord, kindly permit me to indicate. Your lordship will first take up, my lord, what services are we giving?
No, I will not go that deep. You show me from the show cause itself.
I'm very grateful. I'll
Touch and
directly go
page
to the
94 is your reasons for invocation of the extended.
very, very grateful. My lord, kindly take up page 94.
Yes, I'm on that.
My lord, kindly see, and with this, my lord,
Yes.
also permit me to indicate the law, because I'll show from the judgments, my lord, that there is a certain criteria which has to be fulfilled in the show cause notices itself, in this paragraph, which is missing. For
Yes.
that, my lord, kindly permit me to read paragraph 5 once, page 94. The petitioner, CFSPL, is a registered service tax assessee and is well aware of the various provisions of service tax law. Government of India has cast faith on the assessees to declare their correct income details in the periodical returns and assess their tax liability on their own truthfully. And that is how self-assessment in service tax matters has been put in place. I pause here for a moment. So my lord, the premise of the proceeding for the department is that we are well aware, just because we are assessees,
Carry on.
we are well aware of various provisions of the service tax.
Place this paragraph, whichever.
From the foregoing discussion as made in the previous paragraphs herein above, it appears that the petitioner did not declare correct and true taxable income in their respective ST3 returns. Moreover, CFSPL has availed irregular exemption benefits. This is the case, my lord. Irregular exemption benefits while discharging the tax liability in ST3 returns. In fact, it is a fact on record that had the Directorate General of GST Intelligence, Kolkata Zonal Unit, not initiated this investigation, then huge amount of service tax not having been paid by the petitioner would never have come to light, causing huge loss to the government exchequer. I pause here because I'll be relying on a judgment which says this is not required to be done by the SSE. SSE is not required to indicate this to the department. CFSPL has neither reflected the correct income particulars in the ST3 returns, nor did they intimate the department about these taxable incomes in any other manner. In other words, they have violated the spirit and the purpose of self-assessment concept. Hence, it appears that the petitioner has suppressed the facts and figures, including their true taxable income, from the service tax department, and the petitioner has resorted to misstatement and suppression of facts willfully with apparent intent to evade tax. How? Not indicated, and that's required to be indicated. Therefore, for the aforesaid commissions or omissions, it appears that the aforesaid quantified amount of unpaid service tax, as in the paragraph 3 here and above, is recoverable from the petitioner in terms of 73(1) Finance Act. Proviso is not the extended period of limitation. And accordingly, extended period of limitation of 5 years is applicable to the instant case. Interest also recoverable. And next paragraph, my lord, the first line at page 95, liable for penal action. Now, my lord, with this, since I'll not trouble your lordship with anything else, my lord, kindly permit me to directly rely on the judgments, because I don't want to trouble your lordship with anything else. This recording, and now, my lord, kindly see the judgments. Which one is the first? Show me the paragraph. Aban. My lord, may I first start with the classic judgment of escorts? Show me escorts first. Paragraph 17, 18, and 19.
Citation.
But I'm handing over a copy. It's 2015, 9 SCC. 9 SCC 109.
Yes.
But may I first place reliance on paragraph 17. This is internal page, my lord, 21 of the judgment. However, the appellants are on firm grounds when they say that the extended period of limitation could not have been invoked in the present case. In their reply to the show cause notice, the appellants stated, and my lord, it is quoted. Kindly see the second part, my lord. It is submitted that the notices have been manufacturing tractors from 65 onwards till date. Manufacturing process undertaken by the notices has been made known to the department innumerable number of times. Consequently, the proposal to invoke extended period of limitation in the present case is incorrect and the same is liable to be set aside. The noticee points out that just like the department raised issue with regard to IC engines in the year this, similarly department is raising issue in regard to transmission assembly in the present show cause notice. Therefore, department cannot allege any suppression or fraud on the part of the noticee. 20.4, 20.5, 20.6, these are the parts from the letter, the reply in the present case, in that case, my lord. Kindly see paragraph 18. Added to this, the appellants have also clearly stated that not a single transmission assembly has in fact been sold by them in the market. On these facts, we are of the opinion. And kindly see
the
the
case where
test.
challenge of a show cause is there.
We are challenging the show cause notice.
No, in this case, the show cause was subject matter of challenge.
But the extended period was
No,
subject
you
matter
don't.
of challenge.
Yes. So don't go into the merits of the case. Show me that show cause is subject matter of challenge, and in this case, it has been done.
So
So on the issue whether
paragraph 18.
what is the harm on your part to approach the tribunal?
Then what will
Why
happen?
will this court?
Court.
Then the tribunal will not be necessary at all.
It will
This
be.
court
I'll
being,
indicate.
according to you, Mr. Chambag, then the tribunal will not be necessary. This is not a case where the matter went up to the directly from a high court, went up to the Supreme Court. It is from the tribunal this matter went up.
But kindly take up the test
So on
laid
the
in paragraph
question of
18.
merits,
My
the
lord.
court decides this matter.
I'll show from the other judgments.
Show me the judgment, whichever judgment you want, para 7, but this judgment cannot
Kindly
support
take
it.
up paragraph 18 and 19. My lord. It will, because the test is laid down. If this test
Maybe
is not followed,
why will this court examine that?
I'll indicate. The reason is, my lord, the show cause notice becomes without jurisdiction. Any action without jurisdiction.
No, I'm not convinced.
The authority,
Show me the other judgments.
Kindly take up paragraph 18 once. I'll indicate the other judgments. Added to this, the appellants have also clearly stated that not a single paragraph 18, my lord, because here the test is laid down. We are on these facts, we are of the opinion that the appellants would fall within the test laid down in 2 judgments of this court in Padmini Products. I'll show that judgment, my lord. This court held, and kindly see that paragraph 12, my lord. Counsel drew our attention to the observations, paragraph 18, and then
yes.
under that 12, my lord.
Yes,
under that 12.
Yes.
Counsel for the appellant drew our attention to the observations of this court in CC.
Why will I stall the adjudicatory process today, Mr. I have seen the next page.
No, the middle of that paragraph 18, paragraph 18 at the middle, with the intent to evade duty, it was observed.
You may have a very good case. You may have a very good case. I am not saying, but why do you want to?
Because I'll be
stall
submitting
the adjudicatory process.
I'll indicate. I'm not stalling the adjudicatory.
There is an adjudicatory process. There is a forum laid down for that. Why do you want Mr. Bagh to interject that?
Because the Honorable Writ Court, I'll indicate, my lord. The Honorable Writ Court is the only court, my lord, the highest court in the state, my lord, which has the jurisdiction.
Can this issue not be decided by the tribunal?
I'll be submitting to an erroneous jurisdiction there.
Why?
My case is that they don't have jurisdiction. I'll indicate.
Forum is provided for that.
My case is that they don't have jurisdiction.
No, I am not convinced. Any other judgment on show cause?
May I only lay down, indicate the test lay down?
No, I will not go into the issue of, you see, Mr. Bagh, I will not go into the issue whether this invocation of extended period was correctly done or not. For that, an appellate forum is there.
For that, that's my case.
If I accept your contention, Mr. Bagh, then there will be no matters which will be required to go to the tribunal. The High Court you see, all matters are touch and go at the end of the day. At the end of the day, ultimately, the respondent may not succeed in establishing the case, may not succeed. Petitioner may succeed. Therefore, there would be no requirement for the tribunal at all.
I'll request your
there will be no requirement for the tribunal because you please understand this revenue is involved. The revenue, the legislature in its wisdom had thought it fit to put in checks and balances and provide for the remedy in the form of an appeal so as not to make an order passed by an authority. Ultraviolet is the constitution. So remedy is there. Why will the High Court intervene in this case?
May I request your lordship?
You say it's colorable exercise of power.
May I request your lordship to hold on to that thought when your lordship has indicated that it is revenue which is involved?
Yes.
And the respondents may be wrong, but you have to participate. That is where the petitioner, my lord, as an assessee, faces the difficulty. Today, my lord,
what is the difficulty you face?
I'll indicate. If a wrong proceeding is initiated by the respondents, that infringes on the fundamental rights of the...
Is it your case that the person who has issued the notice does not have the jurisdiction?
I'm very grateful. That's my case. That's my case.
Where is your case?
My case
Your case is they may not have correctly invoked the provision of an extended period.
I perhaps have not been able to, my lord, espouse the cause of the petitioner properly. But my case is that, my lord, if they issue a show cause notice, there's a time frame in the law which is given. There's also a provision in the law that in case I want to have an extended period of limitation, I have to fall within this category. The SSC has to fall within a certain category. My lord, I go back to my lord Cape Brandy, the 1922 King's Bench judgment, which says there is
No, we are not here. We are
my lord,
several
there is no
matters.
equity in
We are
tax.
not here for academic discussion.
Well, there is
Mr.
no
Bhag.
equity in tax.
Let's be
Today,
very candid. Do you have any other judgment? Show me, Mr. Bhag.
I will, my lord. I will.
Please. Yes.
Kindly permit me, my lord. Here, my lord, in Escorts 17, 18, 19. My lord,
Yes.
Gopal Zarda is the next judgment. Paragraph 11, I'll rely on, my lord. The only difficulty that I'm facing, my lord, today is if I'm asked to, my lord, answer their jurisdiction, which is assumed wrongly, because that's my case. Show cause notice could not have been issued. They have issued that, they have passed
Please
an order.
understand, if the court admits the petition, the court will put it same terms as you are there. Also, same identical terms, if not better than that.
My lord, my case is
If
this.
not worse terms than you are there. Because
Understand that.
this court has consistently followed a policy. When you approach this court by bypassing a statutory remedy, you must have a very clear-cut case. Very clear-cut
But I
case.
fall within the determination, my lord, of the Whirlpool judgment. My lord, those three categories, my lord,
This is not a
this,
case. Then
without jurisdiction.
it is not a, it is a colorable exercise of power. That a power has been exercised, though in fact the power ought not to have been exercised in this particular manner, because you say they may be wrong in invoking the extended period because they do not satisfy the test. Correct. You may be right, Mr. Bhag. You ultimately you may succeed. But why will this court take on to itself? If
To
this court,
safeguard the SSC, my lord, the rigors of the
then
certificate
according
process.
to you, let me give a go by to the statute itself. I said
But
that
this is an
in future,
extraordinary
from
situation
today,
where, my
no,
lord,
why extraordinary?
because, my lord, they don't have jurisdiction. They
What
have to first
jurisdiction?
show that what jurisdiction, how could they assume? I'm limiting my submissions today, my lord, with the show cause,
Very
the
touch and
paragraph
go
5.
case. Very touch and
My
go.
lord, may I try? May I still try? My lord, I'll
No,
indicate the
cannot. You
judgments.
cannot. Not at the cost of the others.
No, my lord,
Yes.
I'll not. I'll take
Yes.
not more than 5 minutes.
Yes.
My lord, I'll quickly indicate and then I'll rest my case. My lord. But kindly take a paragraph 11. I'll not trouble your lordships with the rest of the paragraphs. Paragraph 11, 12. I'm not even reading out, my lord. Paragraph 11, 12. 12, my lord, kindly see. Mere failure. My lord, this part kindly mark, my lord. Paragraph 12. Mere failure or negligence. And over the page, my lord. Negligence on the part of the manufacturer, either not to take out the license or not to pay duty in cases where there is a scope of doubt, does not attract the extended period of limitation. This is my case. Unless there is evidence that the manufacturer knew that the goods were liable to the duty,
How
or
much
he
have you
has,
been saddled with?
my lord,
How much have you been saddled with?
6 crores, my lord.
Put in 1 crore. I'll admit the petition. Are you ready and willing? Take instructions.
My lord, I will take, my lord,
No,
kindly.
no, take
I'll not
instructions.
trouble your
I'll
lordship
put you that terms. You ready and willing? I'll admit it. I'll hear it out. If you want this matter, High Court to hear out a matter, then you should be ready and willing to bear the cost for the same. Put in 1 crore out of 6 crores. I'll hear out the matter.
Makes very difficult for the SSCs.
Why? Why not?
The reason I'll indicate.
Why? Because you
I'll
have
I'll
the power to move the High Court. Others may not have the power to move the High
Need
Court.
not be that we also have a power of 1 crore, my lord, to secure that kind of
Yes. Yes. Where
in a
where
wrong
is the order?
proceedings. My lord, kindly
is the
take
order?
paragraph 14 of this judgment, my lord, which I just
Where is the
indicated
order?
because, my lord, this explanation
No, where
is
is the
given.
order? Where is the order? Tell me, where is the order?
My lord, the order 101. But before that, my lord, may I only indicate, because I know, my lord, perhaps I'm going south.
10, no, direction, but that part of the direction. I can't hear your matter.
I will not. I'm only indicating the paragraph.
6 crores, 60 lakhs. What is ordinarily the pre-deposit required?
7.5, my lord. 7.
You put in 10%. I'll not ask you to put in the entire amount. Put in 10% of the amount.
My lord, may I take instructions and come back?
Yes. No. Now I'll pass the order now.
Then, my lord, kindly, my lord, I'll only
I'll
indicate
hear
the
you
judgments.
because you see at the end of the day, Mr.
But I understand what is falling
Because
from your
today
lordship.
you
Not
want
make
to
any further
bypass that
submissions.
remedy.
Well, I'll
Now
not make any submissions.
you want to invite the court to go into the merits of the
I
case.
am inviting, but I'll not make
I'm
any
saying you may have a very good case.
My lord.
You may have a very good case. But why will the court examine such a case
I'm
when
trying.
there is an appeal?
I'm trying, my lord. Maybe I'm failing, but I'm trying, my lord, from the judgments to
Yes.
indicate
Challenging
why.
Yashu.
My lord, kindly the judgments, my lord. Only the judgments. I'll only indicate the paragraph.
No. I'm admitting your petition.
No, my lord, before admitting,
I'm admitting
my
your petition.
case,
No.
my case, my lord, kindly.
No. Since I'm admitting your
My lord,
petition, I'm
I'll
not here.
only indicate the judgments, my lord, the paragraphs of the
No, not
judgments.
now.
My lord, the difficulty I'll face, my lord, if, my lord, kindly.
Challenging the show cause 90 days.
So this
So,
was filed in November, 17th
so
of
11th
November
July.
24.
So beyond time.
Yes.
Beyond time.
And my lord, 1 month, my lord.
No, beyond time. There's a provision for condemnation of delay.
Yes, my lord, in the my lord, departmental
What
appeal
is your
says,
explanation for the delay?
my lord, there is really, it's 3
What
months.
is your explanation for the delay?
My lord, there is, it's a writ petition, so my lord, we
No,
have
what is your explanation must be there.
no explanation as such. My lord, we have indicated that there is, kindly see paragraph 30.
You are there to show judgments to the court,
My
to
lord.
show that the court must hear out your matter.
No, my
but
lord,
you
I am
will not
leaving it
put-
to your lordship.
No,
My lord,
but
I
you,
am
but you will not
trying
put in
my
the
best.
pleadings. But you will not put in the pleadings. What is the delay?
That's
Why-
because according to us, my lord, in
Yes.
the writ court, my lord, since it's a writ petition that
So
we have
you are
filed,
you have come to challenge an order
my lord.
successfully stalled in execution of the order for nearly 8 months. So to July,
My lord,
today,
kindly
May.
do not go by that, my lord, presumption.
not?
I'll indicate why, my lord.
Why not?
My lord, because the difficulty is, my
Today
lord,
you did not prefer an appeal.
we did not, my lord.
Today this writ
Because
petition you have
according to
filed in
us, my lord, the
November.
entire proceeding being bad in law, my lord, my doors to the my lord, writ court, my lord, is always open for not only for 3 years. There are judgments, I understand, my lord, 3 years. But my lord,
Challenging the
my lord, may I only rely on the judgments because I'm going to be saddled with 10%. My lord, kindly permit me to indicate the paragraphs. I'll not indicate, my lord, I'll not read out.
challenging the
Only the
show cause
paragraphs, my lord.
I let affidavit in opposition to the present writ petition be filed within a period of
4 weeks, my lord.
You want it expeditiously, I'll place it.
Yes.
2 weeks, 1 week after vacation, liberty to mention.
I'm very deeply obliged. But may I only, I should not be making this
Justice
submission.
Strategy is taking up these matters, all these matters. Proceed before Justice Strategy.
But may I only make this
Yes.
submission? Lord, I leave it to your lordship, but your lordship has
No,
not.
10%. I had said, but
You
you can,
not make any
you can get it reduced by referring an appeal. That I have given reasons why I have put it there.
Let it appear monthly list of July, my lord.
Next door he is there. Yeah, apply for it. That liberty is there.
My lord should hear this matter. We
No, then no, your matter will not be heard. Yes, next matter. First
Very
time.
deeply. It is original said, it will be heard by.
Very well. Then you come back.
I'm deeply obliged, my lord.
2 weeks, 1 week.
Monthly list of July, my lord.
Month list of July. Tale 2 weeks, 1 week now.
May we also have 2 weeks then, my lord.
Yes. Tale 1 week after vacation. And month list of July, reply honor before the matter is taken up next.
I'm very deeply obliged.
So you get more time. Reply honor before the matter is taken up next. Then opposition, month list of July, reply honor before the matter is taken up next. Opposition 1 week after the vacation, summer vacation. Yes, next. Yes.
Please, your lordship. Lord, I'm appearing for the petitioner. My lord, may I first indicate this is a matter which, Lord, props up a very interesting proposition of law. It's from item 2 to item 10. Same, my lord, point. I've prepared, my lord, in one of the matters, your lordship had asked me to prepare 1-page note. It's limited to that 1 page, my lord. I'll indicate
Keep your note. First, let me hear.
Lordship.
Yes.
May I only hand this over because I'll indicate the list of dates from here, my lord.
Let me understand.
Lordship. 6 dates are important, my lord. Kindly don't take up the papers now.
What are you challenging, first of all?
Lord, we are challenging in
Oh,
all these
give me
matters.
that, I will
Lordship, I'm very grateful.
Yes, sir.
Kindly take up the first date. My lord, I'll briefly indicate what the matter is.
No, I remember this matter.
This matter is, my lord, NCLT proceeding initiated. CIRP, my lord, admitted. Thereafter, my lord, section 14 kicks in of the IBC. Moratorium is in place. My lord, we thereafter apply for recalling of this order of admission in NCLT. The order of admission we apply for recalling, saying that the order is inherently expressly bad in law because we are a non-banking financial corporation. NBFCs, my lord, cannot fall within the ambit of IBC. There are Supreme Court judgments on that line. That application is rejected. And my lord, we are, since there is no valid resolution plan, we are relegated to liquidation. In the meantime, we approach NCLT.
It was set aside.
No, my lord. NCLT, the matter was admitted in 2020. My lord, thereafter, my lord, the process went on. Now, the difficulty lies
So
here.
the appeal which was admitted by NCLT was allowed, and initial admission of NCLT, Kolkata was set aside.
That's 2024, my lord.
Doesn't matter, set aside.
Finally set aside. My case is this. All the judgments, my lord, everything that is decided on the field, my lord, is on the point, what happens if a resolution plan is there? That law is settled, resolution plan there, nothing remains. That's not my case. In my case, it was wrongly admitted. Section 14, my lord, initiated. No resolution plan came forth, hence an order of liquidation. A similar provision, my lord, under liquidation proceeding is also available in the IBC that kicks in. Any proceeding neither can be initiated nor proceeded with because that becomes bad in law because of the IBC. And I'll show that. Here, not in all these set of matters, there are several different proceedings which happen. The common factor is
The moment the order is set aside, it is gone.
I'm very grateful. It is gone. During now, the issue that falls for consideration, I've culled it out. I've tried to cull it out, my lord. Kindly see after
All
the table.
list of dates is applicable for all the matters. No, are different.
All the matters essentially, my lord, because it's different because all the proceedings are different. But essence is all the proceedings happened during the pendency of this, my lord, proceeding in CIRP. Now, first what I need to show to your lordship is, my lord, 18th January 15, 2018 is an important date. That is when CIRP was initiated. That's the first date, my lord. After that, in all the proceedings, I'm only relying on this proceeding, my lord.
Assuming Mr. Bagh,
My lord.
today, if this was not admitted and it would have been liquidated,
Lordship.
what would have been the effect?
All these proceedings would go.
Correct?
My lord. All these proceedings
So
would be
you have
bad in
taken
law.
a chance.
My lord.
You have taken a chance.
We have not taken a chance, my lord.
Yes.
No, my lord. That's where
The
my lord,
orders have been passed. You did not do you
I
participate?
could not. That's my case. I could not.
No.
My lord, I'll indicate. Kindly take up section
Why you
14.
could not
I'll
participate?
indicate. Now, kindly take up section 14 of the IBC. It's only the resolution professional who can participate, not me, my lord.
You are prefer an appeal from the order.
But I don't
Because
get
throughout. That
I
does not
don't-
necessarily
my lord,
mean
I'll
that
indicate.
the appeal will also be preferred by the resolution professional, Mr. Bagh.
No, my lord, I'll
The
indicate.
appeal not. You had preferred an appeal.
Appeal,
Or in existence.
appeal, my lord, I have preferred against the order of CIRP.
Correct.
That's different.
So you could have
Today,
proceeded.
no, my lord, I could not. I'll indicate. That's the law, my lord. I cannot
Show me
proceed.
the law.
Subject to being corrected by
No,
your
no, show
lordship.
me.
my lord.
Yes.
Kindly take up section 14, my lord.
Yes, দাও আমাকে দাও। Insolvency Act দাও একটা।
I may be corrected, my lord, because this is
ওই পাশে
something
আছে, ওই
which
পাশে
is,
আছে।
my lord, bothering us.
ওই পাশে আছে। Insolvency Act আছে দাও।
Insolvency and Bankruptcy Code. I'm sorry for troubling your lordship like this, my lord.
They have returned it. ফেরত দিয়ে দিয়েছে নাকি?
My lord.
ফেরত দিয়ে দিয়েছে নাকি আগে ছিল এতে গ্রুপ 3 তে পুরোটাই ছিল। Yes, yes.
My lord. Subject to the provisions of subsection 2 and 3 on the insolvency commencement date.
Yes.
Lord, kindly take up item number 3 with this because I'll indicate from that page.
Whichever one you want. There
My
is no difficulty. Yes.
Subject to the provisions
You're
of
ready.
2 and 3.
Ready,
My
ready,
lord. The
ready.
adjudicating authority shall.
You are ready.
I'm ready, my lord.
Yes, yes.
With all the judgments, I'm ready today.
No, no, because I'll be deciding this.
Yes,
Whichever way
kindly,
it goes.
kindly,
Yes.
kindly.
Yes.
It's a question which falls for consideration by your lordship. My lord, I
No,
beseech you,
either I admit or I whatever means
Whatever,
I not
whatever.
adjourn it. Yes.
My lord, kindly don't. I'm ready.
3 নম্বরটা দাও এটাকে সরিয়ে দাও 3 নম্বরটা দাও Yes, section 14. Yes.
Shall by order declare moratorium for prohibiting all of the following, namely, the institution of suits or continuation of pending suits or proceedings. Here we fall under all proceedings, my lord. Against the corporate debtor, that's us here, my lord. Including execution of any judgment, decree, or any order in any court of law, tribunal, arbitration panel, or any other authority. So we are covered under this A.
On what ground did you challenge it? The order passed
Because
by the NCLT?
I'll show that, my lord, from the records. I'll indicate right now. We are an NBFC. The
So
law
according
is,
to you, these proceedings could not have been initiated against you.
Lord, we are here, my lord. We are tied. Our hands are tied. We are not able to act once the CIRP initiates because we lose control of the company. Company is no longer in our control. It is then in the control of the IRP and then the RP. And if it is in liquidation, then in the liquidator's hands. I have no control. I
You
can't
had
do
no
anything
control
for
of the company.
No, I don't.
For which period to which period you had no control of the company?
2018 to 2024. 6 years I was. That's what makes it unique.
So the insolvency professional conducted the business.
We intimating when it is admitted, the first thing that they are required to do under the law
Did he
is
take
have
over
a
position?
public announcement.
Did he take over position?
He did.
How?
But that's the order.
Show me.
I'll show you, Lordship.
How did?
But before that, Lord, may I complete reading
No,
this, my Lord?
no, then I'll come back to 14. 14, you see, 14 is under challenge. Validity of 14 is under challenge.
No, it's not, my Lord.
After everything. Once the order goes, everything goes.
Subject to be corrected, my Lord, subject to being corrected by your
Yes,
Lordship.
yes, yes.
My Lord, from 18 to 24, my Lord, as the original company, the management of the company, I lose control of the company. I can't do anything for the company. If there's an order against us, it's the IRP who has to take it up. And the IRP also, my Lord, is only required to have a public announcement that CIRP has been initiated against this SSE, which means that the respondent authorities or anyone
Under which provision? Under which
under
provision?
section 14, and that's been clarified by the Supreme Court
No.
and our High
Under
Court.
which provision this CIP proceedings was initiated?
Under section 7, my Lord. Kindly take up page 40. It will be evident. Page 40 of the petition, my Lord. Page 40.
Yes.
The first line. An application under section 7 of the Insolvency and Bankruptcy Code. I'm sorry.
Yes, yes. Continue. It's all right.
Page 40.
Yes.
Taru. an application under section 7. So as a financial creditor, my lord, Olympia Credits filed
Where is
against,
your appeal? Where is your appeal?
my lord, our appeal. The order is annexed. The
Which page?
order of admission in the appeal, may I first show, my lord? It's page,
No, show me the directly. Show me the admission order.
the admission order is at page 48. In the notes, my lord, your lordship will find. In the notes that I have given, my lord, it's serial number 4, page 48.
Oh, I see it's there. Yes, yes.
My lord.
They do not, their admission
They
orders
admit,
are
mere admission,
Yes.
paper books. Now kindly take up,
15.
my lord, what happens, no, before that, my lord, kindly take up page 82. I'm sorry, my lord, page 76. Page 76. This is, my lord, the subsequent order of the NCLT, whereby, my lord, liquidation has been initiated by the NCLT. And this is on January 2, 2020. May I only, before I proceed any further, refer to the direction of the NCLT at page
The
47.
jurisdictional issue is there.
My lord,
Pecuniary limit less than 50 crores. So therefore your assets are less than 50 crores. You are exempt from the ambit of the provisions of the court.
well, that's for the liquidation COC to decide. No, this is not the, my lord, the NCLT's domain. Kindly take up, my lord, page 47 once, my lord, 46. May I indicate once? Because this will be very important for the matter.
The
part
appeal
of
was
the
allowed on the ground.
appeal was allowed on the ground that I am an NBFC.
Yes.
I'll indicate that. My lord, kindly take up page 46 once. I'll
No,
come
no,
back to it.
come to paragraph 20, page 60.
Your lordship
appeal.
is referring to, my lord, page
60.
6.
Yeah, appeal was allowed on this ground.
Yes, but the appeal was allowed on the ground that this is an NBFC. Your lordship will find it paragraph 20.
Yes. Yes, correct.
That, lordship. So that's the ground of appeal.
And the assets are less than 50 crores.
So it's not maintainable.
Correct.
Correct. No,
So entire order is bad.
entire order
The jurisdiction, initiation,
That's-
assumption,
look,
everything is bad.
there, my lord, may I indicate it is not so. It is bad, definitely.
Today having
yeah,
succeeded
I-
in
I-
the
I'll
appeal.
I'll indicate. It is all bad. I agree. While a proceeding has happened during the subsistence of this proceeding, what is the fate of those proceedings is the question which falls before your lordship. And it's a very pertinent question, my lord. Kindly take up page 46 once and I'll indicate why this is pertinent. This is the order of admission in CIRP in 2018. So 18 to 24, my lord, I had no control of the company. And I repeat, my lord, I had no control of the company. Kindly take up why. Page 46, my lord. Your lordship will kindly take up page 46, paragraph 19, 1, 2, 3. What is this, my lord? Kindly see paragraph 19, the last line at page 46. Is the second paragraph at the page. My lord, the last line before 1, 2, 3 starts, paragraph 19. Accordingly, we admit this application under section 7 of the IBC declaring moratorium for the purposes referred to in section 14 of the code with the following directions. Direction number 1, that this bench, subject to the provisions of subsections 2 and 3 of section 14 of the code, hereby prohibits the institution of suits or continuation of
Question that falls for consideration, Mr. Bagh,
My
in
lord.
this matter is very simple. Whether the order passed by the appellate authority has the effect of removing the authority or jurisdiction of NCLT to pass any order in your matter, or whether from the date on which the appellate order has been passed, the professional will lose the right to proceed, or all his acts and conducts done in the interregnum will be accepted.
I'll pause here for a moment, my lord. Subject to, my lord, permission from your lordship, may I try and address this as the moment there is an order of the appellate authority, my lord, setting aside the original order of 2018. What is fallen from your lordship
This is
whether
no
the-
ordinary order. This goes to the jurisdiction.
Absolutely, my lord, absolutely. But
It
what?
says
So, my lord,
there
any-
was competence. There is no competence to pass the order.
Very
So
good.
all acts done is bad.
I'm very grateful, my lord. Acts done by the IRP. But, my lord, today, during the section 14 stage, if there are proceedings by the respondent authorities under the tax law, what would happen has been decided by the Honorable
Those
Supreme
will vanish in thin air.
It will, my lord. I'll indicate that.
Show me.
Kindly permit me to first
Show me.
analyze this part.
No question. Analysis is a very simple issue.
Without
on
this, my lord, that will not have any, my lord, effect. Kindly
You want to
permit
show
me
me
this.
any judgments on this?
But that's why I started. I'll show 4 judgments.
Please show me
But
judgments.
on this point, it will fall for your lordship's consideration because I've done my research, my lord. Exactly on this point, similar issue that in the appellate stage after 6 years, this order is set aside. And my lord, whatever has been done by the RP may be bad. But while section 14 was in operation, whether anything could have been done, and if anything has been done, whether that is bad in law, I have judgments. But whether this part, my lord, whether it will relegate back, it's like status quo ante. Whether status quo ante can be permissible in these
Here is
facts,
the question.
because here a
Here is the
statute is
question.
staring at us, my lord.
Here is a question where you say that it had no jurisdiction.
My lord. I don't say that, my lord. I stand
Yes, you
corrected.
prefer an appeal.
The statute says that, my lord.
So you say that.
Lordship.
You can't blow hot and cold at
No,
the
I'm
same
not, my
time.
lord. I'm not.
You say that there is no jurisdiction so far as you are concerned.
I'm saying that I have been saying that with my lord. That was screaming out the headlines
The order was bad.
for 6 years.
Can you be permitted to take advantage?
I'm not
Having
taking an
said
advantage.
absolute advantage.
No, my lord. Kindly take up the
Under
law,
section
my lord. I'll
14.
indicate. Kindly.
Or were you being prevented from being represented before the tax authority?
I was prevented, my lord. I was prevented. And I'm very grateful.
Show me that.
Very, very grateful.
If you can show me that you are prevented, I'll allow the application.
That's, my lord.
That's
in-
the only thing,
with
nothing
all
more.
the, I'm very grateful, my lord. With all
Find
the
out and tell
humility.
me. But I'll come back.
My lord. I'm
Find
sorry
out
for
and show
troubling
me.
your lordship
No, no.
throughout the.
Find out and tell me that.
I'll indicate that. But that's the provision. I'll indicate it. No, my lord. When the RP comes in, I have no control. We become the suspended board of directors with no control. We have no say in the matter, my lord. My lord, would you please to take up section 17, my lord, of the IBC?
What is the position now?
Milord, in all cases, Milord, the assessment order has been passed.
Already passed.
Already passed. And Milord, in some cases, I'll tell your lordship, Milord, in fact, the first case, the assessment order was passed even in 2017. And 2018 January, the NCLT order was passed.
So there's no
Kindly-
urgency today.
There's no urgency, but may I only indicate since it has fallen from your lordship?
No, there is no urgency today. Only the 17 matter.
Yes.
I'll segregate that. That is before the order passed by the.
My lord, the
NCLT.
urgency is this, my lord, if they proceed
No, if there is
against
an
us,
order passed prior to the NCLT, this defense is not there.
we could not prefer an appeal, my lord, from
And
there.
Milord, another thing, Milord, 2011-12, assessment year 2011-12, Milord, the
We
order of
indicate that
ass-
number. I'll place these matters after the vacation.
the assessment order was passed in December 2018. But Milord, this petitioner filed an appeal against that order, assessment order. That appeal papers are
For
also
admitted
there.
itself, we have seen that.
That itself, my lord, it becomes invalidated, my lord. I'll indicate why.
And I'll hear you.
My lord,
I'll hear you.
96
Only may I indicate, since it has fallen from your lordship today, my lord, how is the management taken over? My lord, kindly see section 17 of the IBC. I'm sorry, my lord, I'm troubling your lordship.
Yes.
Only one provision.
No, I have to hear
On
this.
the order also, I'll show, my lord, that this is
Maybe you might have some case, but may
it's a
not
very
be.
unique situation, my lord. I'll indicate. From the section 17, my lord. Management of affairs of corporate debtor by interim resolution professional. From the date of appointment of the interim resolution professional, the management of the affairs of corporate debtor shall vest in the IRP. The powers of the board of directors or the partners of the corporate debtor, as the case may be, shall stand suspended and
No,
be
it's
exercised by the IRP.
bad. Now it has been declared everything is bad.
Because the time frame
Now
is
you have to
gone.
argue that,
My
Mr.
lord.
Bhatt. You
My
have to argue that.
Even if it is bad, my argument will be this, my lord. Section 14, while it was in
Forget
operation,
14. Assuming Mr. Bhatt, say for instance, he has sold a particular property
Lordship.
or auctioned it, say for
My lord.
instance, and it is held to be bad.
My lord.
Will you accept that?
It's the action of the IRP. Today, my lord, the consideration is the action of the income tax authorities vis-a-vis, my lord.
So simple.
No,
Anyway,
it's not. And that is why, my lord, I'm
so I'll
telling
hear you.
those-
Accepting that matter. Which matter is that item?
But that matter also falls within this domain. I'll indicate.
No, no.
It also falls within the same domain, my lord. Until and unless, my
No,
lord,
no.
it
You
has to be-
indicate that matter. Which matter?
Item two.
Two.
this is item 2.
That's very well.
Item 2 also I'll indicate. It is not really-
Item number 2 তে this আলাদা দুটো গ্রুপে আসবে হ্যাঁ একসঙ্গে একটা অর্ডার হবে একটা আলাদা অর্ডার হবে list this matter for further consideration under the heading forwarders having heard the learned advocates appearing for the respective parties list this matter under the heading forwarders in the month list of July নয় month list of June আর ওই অন্যটায় সেম অর্ডার দুটো একসঙ্গে একটা অর্ডার
There are different assessment years.
different assessment years, my lord. I'm ready to argue all separately.
ন্যাচারালি সো
I'll do that.
দুটো সেট আলাদা দুটো ফরওয়ার্ডার্স এর আসে দুটো
Three, Milord, the
I'll hear him on that day.
that he has preferred an appeal against my assessment order. So
There
even
are-
the RP was existing that time.
Appeal is there.
Yes, appeal is there.
And that's bad in law, I'll indicate. There are judgments which say that.
He's saying I have done something
Well,
bad.
in
I could
July-
not have done. If
July,
I
why-
can't do anything in law, then, my lord,
But
it's
he
not,
has
if it is not
done.
permissible, I have done, it's bad in law.
And
That's my argument. You have
has
done
been
it, bad in-
admitted.
I'll come back, my lord. I'll come back with a one-pager note for every matter, my lord. Then because it will become easier.
Yes, call the list. Next.
I'm very deeply obliged, my lord.
Please, your lordship, I'm appearing on behalf of the petitioners in this matter. Lordship would recall this matter is a matter where I was not being able to log in my portal. So thereafter, my learned friend had assisted me in resolving such issue. Mr. Sharma was appearing on behalf of the respondents. On the last occasion, Lordship had expressed your Lordship's mind to relegate this matter back to the stage of 148 AB. Lordship has also asked Mr. Sharma to get back with necessary instructions.
Lordship will recall this is that matter where admittedly we could not have.
Yes. Challenging the orders
the order has been set aside, now that limitation will start.
And it's
the date of-
24, my lord, so I don't think limitation would come. Lordship's taken care of.
Disposed of.
I'm so grateful, my lords.
And for the petitioner, Your Lordship. Your Lordship, in this matter, an order was passed by Your Lordship on the last occasion.
Louder, madam.
In this matter, Your Lordship, an order was passed by Your Lordship on the last occasion. Your Lordship, if Your Lordship, may I recapitulate the fact, Your Lordship, quickly? Your Lordship, what had happened in this matter, Your Lordship, may I, Your Lordship? Your Lordship, I'm just handing over a chart. I'll also hand it over to my learned friend. Immediately before this consignment, Your Lordship, 3 other consignments, Your Lordship, were 100% examined. They admit that goods are identical or similar goods, Your Lordship. Your Lordship, Your Lordship would see this chart. Your Lordship, on 30th January 2023, first bill of entry, Your Lordship, 100% examination. And Your Lordship, here, Your Lordship, it was first check. First check, when the party is not sure, they leave it on the department to ascertain under what classification the goods should go. So Your Lordship, they checked it. And Your Lordship, there is a, Your Lordship, I've put it in quotation. Please see if the goods are indicator panel or display panel. This is precisely the dispute in this matter now, Your Lordship. So Your Lordship, they checked it for 100%. And Your Lordship, they classified it as indicator panel. Thereafter, Your Lordship, the second bill of entry on 21st March, 100% examined, department classified it as and allowed it as indicator panel. Third, Your Lordship, 14/9/2023. This, Your Lordship, the reference of this is there in the order. And Your Lordship, this fourth consignment was intercepted. And they said it is indicator, not indicator panel, display panel. Thereafter, Your Lordship, this matter was adjudicated. No appeal was preferred. Then, Your Lordship, the second chart I am just giving. Your Lordship, I'm sorry, Your Lordship, I had. Yes. Your Lordship, they have reopened all my import. They admit that it is identical and or similar goods, and they want to open up all the imports from 2019 onwards, invoking limitation. So, Your Lordship, this is a composite writ petition. I have challenged both, Your Lordship, and Your Lordship, on the last occasion, Your Lordship was pleased to direct them to take instruction and come in the matter.
All right, I've taken instruction, my lord. What has happened in this case is they have declared, which I will say is misdeclared, these goods as LED indicator panel.
That I understand. Now the issue is clear. Declaration is, it's a case of misdeclaration.
Yes.
Correct.
And why, my lord?
But
They
the
have-
question is, you had allowed clearance by checking this.
My lord, they have made self-assessment. Now, as in so far the impugned consignments are concerned, they were all self-assessed. They made self-declarations. They were interdicted. They were intercepted on the basis of the intelligence. They have declared these goods as LED indicator panel classified under CTI 85312000. In fact, this should have been declared as LED flat panel display module, because these are the impugned goods which are multifunctional. They have declared these goods as LED indicator panel only to get advantage of the exemption notification, whereby those goods become zero duty. But in fact, these goods carries a basic customs duty of 10%. They want to evade that. In past also, they have done that. For that, we have carried out investigation, and we will be showing in the appropriate show cause notice. Now, Lordship, we have already issued a show cause notice under section on 3/4/24.
28. Under section 28.
No. I tell you, Lordship, we've on 3/4/24 issued show cause notice under section 17(4), read with section 124, praying
124, yes.
praying for reassessment, reclassification, confiscations, and penalty. That was adjudicated upon. The adjudication order till now remains because it remains unassailed. it was classified that these goods are LED flat panel display module carrying basic customs duty. They have not challenged it. The period for challenge is over now. Now we have filed, we have issued a show cause notice under section
So
24
under the
for the
Customs
duty
Act,
foregone.
if time is, there is an appellate provision,
Yes,
but is there opportunity to file an appeal beyond the prescribed period?
prescribed period is for 90 days. That is gone. 60 plus 30 days under section 128.
So that is,
And
so
and the
beyond
order
that,
was
no appeal can
and
be.
the order was passed on 5/6/24.
Beyond that, can any appeal
No,
be favored?
No, so Lordship, can you see section 128?
No, I'll accepting that. What you will. There is not
My
an issue
reading,
here.
my
That is
reading
not
is
an issue here.
my reading is no, it cannot be.
Then I have to hear out this. Actually, I can't throw it away. You file opposition.
Now, Lordship, can you see this is now that order is appealable. Now she has also challenged the show cause notice which has been filed under section 28(4).
I'm not granted any stay.
Lordship kindly indicates that.
Your lordship,
Not
in
granted any stay. Ari,
only your lordship directed that they will not proceed on the basis of the second show cause.
No,
Your
Lordship.
lordship,
no,
why?
that I permit them to proceed.
Your lordship, your lordship, I will satisfy your lordship. They cannot proceed. Your lordship, here,
No, you go and respond.
your
I'll
lordship,
grant you liberty to respond.
lordship,
Go and respond. I'll
I-
keep the matter pending.
your lordship,
In the
I have,
meantime, let them file
may I-
affidavit.
may I,
Yes,
your
yes.
lordship? Your lordship, in the writ, I can challenge the order or which I have not preferred an appeal also can be challenged in writ. Your lordship, I'm carrying judgments. Your lordship, because your lordship, here a miscarriage of justice takes place. Your lordship, they are examining the goods, they are allowing it, and your lordship, they want
To
to.
examine this,
Your lordship,
madam.
but your lordship, in the meantime, your lordship,
Otherwise,
let the
without
order
examining
continue.
it, I cannot.
Your
So I
lordship,
have to examine it.
that order, your lordship, that limited that they will not proceed with it because second
No,
show cause is
to
absolutely
respond
bad.
to the show cause.
Your lordship, I have got judgment that second show cause extending the period of limitation in case of classification dispute is absolutely bad. Division bench of this High Court also.
Ari, what you do this? You respond it. I'm not permitting them to pass any order and
Your
enforce it
lordship,
against you.
there will be a multiplicity.
No, why multiplicity? Without leave of the court. But let the proceedings be completed.
They will not pass any order, your lordship.
Correct. Having got the learned advocates appearing. Now, today, Mr. Day, learned advocate, by placing before this court
Not have gone correctly.
Place this matter immediately thereafter. যদি না হয় তাহলে জুলাই হচ্ছে না 2 weeks এর পর month of September August, because 4 weeks will take you mid of July.
Your Lordship, the bill of entry number may not have gone correctly. May I hand it over, Your
Yes,
Lordship?
yes, yes.
This
ওই bill of entry নাম্বারটা দিচ্ছি সঙ্গে রেখে
earlier transaction, Your Lordship, which earlier bill of entry which was allowed, E number ta hoga.
next.
Grateful, Your Lordship.
Grateful to your lordship.
Item number 30.
I beg to appear on behalf of the petitioner, my lord. I'm a courier service, my lord. My clients,
No. আগেরটা
My lord, I will be taking the question of maintainability.
yes.
my clients' goods were confiscated, my lord, and under 125, I wanted redemption. I lost before the commissioner. I lost before the sestat. I preferred an appeal before this honorable court. That order is at page 53, my lord. 24th April 2019. The entire gamut of events will be evident from this order, my lord. By the consent of, I'll not trouble my lord with the first paragraph. As matters stand now, we don't find any infirmity in the impugned order of the tribunal dated 4th May 2018.
Tribunal's order has been confirmed. Well, just a small tribunal's
but-
order has been confirmed. Some leverage has been given
Yes,
by the
yes, that-
division bench.
That
Your
is
lordship
all.
will come to page 55.
Yes,
which
that
is
is.
with a condition of 2 months, because it has been confiscated. Now he has not demonstrated from his pleadings that he has paid the confiscation fine and penalty. And in the tribunal's order, 3 persons were the appellants. 3 persons were the appellants in the before the division bench. Over here, only 1 person is appearing. Now, whether the order in original has been complied with or not is not evident from the pleadings.
I was only humbly praying for consideration of my representation, nothing
Why
else.
consider it?
And I'll show why the division bench gives me time of 2 months.
From
I
there-
made my representation beyond that. That is
Seek modification of the division bench order.
And that
I am not competent to direct that.
that leverage goes. It is under special circumstances the divisions have bench. though
I'll grant you
confirming
that.
on the order.
I will not say that you are not entitled to. I will only, if you want to withdraw, you withdraw and go before the division bench.
He has to go.
I think it is better.
Yes.
I cannot do that. You are seeking modification of an order passed by the division bench.
my lord.
Though the petitioner
And under
speak-
one
reconsideration of his
between my lord.
Go there, say so. The power to extend is inherent with the court,
That
but I cannot do it.
I bow down to your lordship. I bow down.
I cannot do it. It is for the honorable judges who had done so. Now the honorable Chief Justice is there, so you ought not to have filed the writ petition. You ought to have. Anyway, it's up to you what you do. I do not know. A wonderful court.
Yes.
Item number 14.
14, 15, 16 has been rendered infructuous because this was challenged to 148 proceedings. And my lord, assessment order has been passed and SSC has also filed appeal.
See all three. All three.
Nah, man. What are the
So date is not.
There is one connected matter, my lord. It was taken up earlier, but no stay was granted. Yeah, the same. So maybe in that matter also order may have assessment that
Lord, I have to see, my lord. My learned friend is saying I will mention and will get it disposed of. If
Item
because
number
client
17.
has not come up, just I saw from the portal, my lord. I have to be fair. My lord. My lord, even one day, one day, even my lord, then it will be. That will be of great help, my lord. My lord.
there are there are several small matters, my lord, in which either assessment order has been passed or application has become infructuous.
Item number 17.
Your Lordship, I'm praying for a nod today in this matter, Your Lordship. Lordship, Lordship, I'm being led by by my learned senior in this matter, Mr. Bagh, for another courtroom, Your Lordship.
May I subject to lawsuit correction, my lord? Now, my lord, this is a my lord 148 order passed, my lord. AD order passed. AD order passed, my lord, 31st March 2024. There were writ petition and filed, my lord, affirm, not file, affirm, my lord, in the month of February 2025. Thereafter, my lord, in the writ petition, there is no averment that they have participated in the assessment proceedings. Assessment order also been passed. This is the assessment order. Yes.
Your Lordship, my only difficulty is not even briefed in the matter, Your Lordship. I'm not even carried. Found to ensure that my learned senior is here in this matter.
Nothing remains, nothing. My and in this writ petition only challenges 148 order under section 148 AD, and there is no averment that he has participated in the proceedings.
I'm only praying for a not today, Your Lordship.
Tomorrow, not tomorrow, my lord. Tuesday.
The petition has been filed. Not signed, so that but the assessment order has been passed, now it remains. The petition has been filed in India. Challenge. Kannam Devi also needs 148. Actually, that is the tax 61 details. 20th March 2024. And the order under section 148 capital A within D of the say that dated 31st March 2024. And internally including under section 148 of the state act dated 31st March 2024. In respect of the assessment year
1718, 1718.
Let me check up. This is the main thing. Because it is not 1718. Yeah, 1718. The records Mr. The principal act. I just recording that I have heard, but to make it getting the thing. Contents at the very outset is pleased to scope. Yes,
18th March 2025.
Under section 147, relate with section 144, capital B of the same act. 147 and section 140, capital B of the same act, dated 18th March 2020. And submit submit instructions. Let a copy of the assessment order passed under section 147 of the state act, dated 18th March 2025. Taken up. Hoping that the assessment order has been passed. I am of the view that there is no scope to challenge under section 148 capital B or the order passed under section 148 capital A brackets B and the notice issued under section 148 of the state act. And in this stage, the petitioner has otherwise an efficacious remedy in the form of an appeal. The appellate authority, government, Assessment order passed under section 1. Say that. So we think that of it. Scope. There are stop the is this is any challenge on what?
Lordship, I'm not briefed in the matter. That's my only issue today, Your Lordship. It's unfortunate, but as much as I would like to assist the court, Lordship, I'm grateful. I'm grateful, Your Lordship.
Being an officer of the court, there
Challenge is there.
is a one challenge on the part of the assessee that in the serial number 13 or 15, there is a recording that he has not given the reply to the 148 AB notice. But subject to lordship correction, I have some submission to that effect. In the approval part also, the yes, considered. That is my submission. May I?
Not in a position to defend myself, Your Lordship.
May I subject to lordship correction because I'm not an officer of the court. I don't suppress anything. There is a no. Yes, there 151 approval. There is a recording. 150. He has filed. The assessee has filed one reply. But subject to lordship because I am the officer of the court. I have the assist to your lordship. But my yes, page is
That is the main thing. That is the only issue. Approval is
that is 316. Serial number 15. 316. Your lordship got it. Serial number 15. Now I have some submission to that effect.
yes, Mr.
I'm so sorry, Milord. It's on legs. Kindly do not dismiss it, Milord. There's one point. I know, Milord. One point has been taken. Appeal has been preferred. I'll indicate from the grounds. It has been, and I'll indicate. But no, it can't be. I'll indicate why. Kindly take this after, Milord, the recess, because I need to point out, Milord. Then I leave it to your lordship. Well, it is not preferred. I'll indicate that part. With a clause, that one page. The reason I'll indicate, Milord, without that, then it will not be like a Damascus sword, Milord. It will fall on me. Milord, kindly keep it after the recess, Milord. With a rider, Milord, that since the writ petition is pending, we are willing to withdraw this. Milord, we do not want to, we were going out of time, Milord. We had mentioned this matter several times. Milord, kindly do not, without hearing us, Milord. I'll take 5 minutes, I'll leave it to your lordship thereafter.
You closed it.
I have submitted on his behalf.
No, I can't lie to the court. I'll indicate if it is filed. Of course, I'm sure. When my learned friend is appearing, definitely. Discrepancy. There's one glaring discrepancy, Milord. Milord, kindly don't relegate us, Milord. May I just indicate? Give me, Milord, 2 minutes. I'll indicate, Milord.
No. Your lordship, even if Milord approval is bad,
but approval is absolutely bad.
For the sake of argument,
Milord, kindly take up, Milord, once.
Milord, even
I'll indicate, Milord. Kindly take up page 316. 316, Milord.
Tell me what are the challenges. Do you have challenging notice?
No, my challenge is, Milord, First, Milord, first thing It's covered by a Supreme Court decision, the line of decisions of Kelvinator and
Yes,
Texpac.
also hundreds of Supreme Court decision. 148 AD stage, the court will not interfere.
Challenge the notice 148 AD.
We have, my lord.
Challenge the order on 148 AD.
We have, my lord.
Challenge the notice under section 148.
We have, my lord. That's all, my lord. This I'll indicate that it could not have been passed. Give me 5 minutes, my lord. Kindly give me 5 minutes. I'll indicate that. If your lordship, my lord, since my lord, it's very, may I indicate right now when I was coming.
Very pause the order. The junior has already got that point.
My lord.
There is a absolutely
151. I understand that. And that I'll show, my lord. Page 316. That's what I start with.
challenge to them. That's why I asked.
But the waters are rough, my lord. I'll indicate this. The waters are very, very rough. Lunch break, my lord. After a good sumptuous meal, it will become a little calm. Kindly permit us 5 minutes after the break, my lord. Because we understand the waters are extremely rough right now. Kindly grant me 5 minutes. Kindly have the lunch and come back, my lord. We'll come back. We'll do it on the next day, my lord. Kindly grant me 5 minutes. I'll not. Tuesday we'll do it. Tuesday, my lord. Is 1316. My lord. With a rider in the grounds. My lord. My lord, may I indicate?
May I subject to correction, lordship, correction?
Hearing you on that.
No, my lord. I am
on
adding
Thursday,
something.
kindly
I am
keep this,
adding
my lord.
something, my lord. Your lordship can direct the appellate authority to hear out the appeal and dispose of the appeal within certain limited period. No point of pending repetition here.
No, we will withdraw. That's our ground in the appeal.
Yes, all points, my lord. Similar, no, similar, my learned friend.
No, I have pleaded. I've pleaded that.
My
Will kindly take up. We have pleaded. Will kindly see first 316 is the Milord. I'll show from the pleading. Kindly grant me one moment. Milord. I am taken by surprise. Milord. Kindly grant me one moment. This is a very valid question. It's in our grounds is there.
Paragraph number 29.
It's page 22, Milord. 20,
Yes.
21 and 22.
Not that, Milord, not pleaded.
We have pleaded, Milord. I remember.
Milord, I am saying,
Paragraph
Milord, I
29.
am not only this point.
Milord, may I indicate the
SSC
points?
have-
Kindly give me 2 minutes. I'll indicate the points. Then I'll give it to your lordship.
May have another point. Let it be decided in the
I
appeal.
can't hear his lordship. I'm so sorry. Please. My lord. My lord. We have indicated in the grounds of the appeal, Milord, that the writ petition is pending.
But still, since this point is left to this extent, I will direct the appellate authority. Here, this point of
Also, one more point, Milord, if it can be directed. One more point, Milord. May I only indicate this? Milord, since my main challenge was that all these documents were with the respondent authorities all throughout. They could not have, on the same documents, revisited the issue.
All points.
But that will be
all points.
but because I had those two judgments
All
in.
points.
Why have you?
has not challenge sanction granted under section
1 April.
As rightly pointed out by Mr. Bag.
Yes.
By Mr. Bag.
Yes, what he have said mechanically, what he have said. 29, paragraph
29, Milord.
29. Challenge. So, sanction order. I am of the view that the above petition should be decided, should also be decided by the appellate authority.
Along with other points. Along with other points.
Milord, with so sorry, Milord.
Shall upon giving an opportunity, shall upon giving and upon calling for the records, including the sanction granted under section 151 shall decide upon the appeal
Including my lord, paragraph 28, change of opinion. Kindly indicate that, my lord. Because that
all point, my lord. Yes, all
that
point
PDF, my lord, robs them of that jurisdiction. That same point, my lord. That's something, my lord, which is beyond my control. It's
Bhattacharya had showed me this.
my lord. It is actually, my lord, beyond my control.
My lord,
But my lord, either way, my lord, I would have started my submission by, my lord, opening my cards that I filed an appeal. I would have done that. That's the first thing I would have done, my lord.
my lord, I am the officer of the court, my lord. I cannot.
I understand that. I understand. I'm very deeply obliged, my lord.
This point he will decide.
Yes.
He will not take this point in the petition. He will not challenge this in the petition. After recording that,
Not here.
My lord, in the prayer portion, no, but my lord, in the grounds we have taken, my lord. In the grounds we have indicated, my lord, that this. And I'm very deeply obliged for the patient here. I apologize for. I'm very deeply obliged, my lord. Lord, appellate sign. But may I only indicate this Tuesday? I'm in some professional difficulty, my lord. My juniors may, if my lord, kindly consider, my lord, because I may not be in town, my lord. Lordship, my lord.
My lord,
আমি দুই মিনিট সাথে করে দাও, একটাই তো আছে।
Daily list item number 1.
Non-prosecution. The communication.
Yes,
Non-prosecution. Matter has been settled.
settle. The learned advocate settled.
Settled.
Settle.
Taking the advantage of the scheme, Lords.
Department is settling it.
We are very well
The learned advocate for the petitioner would submit that in terms of
I tendered apology.
paragraph having regard thereto. Yes,
Tendered apology, my lord. Wanted
Item number 2.
only by that line. Where were you yesterday?
36 minutes. Some 36 arbitration matter.
You're going for arbitration matters during the court.
No, arbitration matter was taken up by
Arbitration
36 petition.
Yes, দেখি অর্ডারটা বলি, কালকের অর্ডারটা কোথায় সই করে নি? আরে বললাম তো অর্ডারটা পাঠিয়ে দিতে। Yes, the e-way bill was valid.
My lord, whatever the instruction I
I've read it. E-way bill was valid.
yes.
That you did not answer. That is not there.
My lord, whatever happened, my lord, there are disputed facts.
Maybe.
No,
No, e-way bill was valid. I am not hearing. I will record your submission and let it go.
my lord, I'll tell you, my lord, whether my lord, the driver was carrying it at those facts because I had shown the.
People may not be carrying it. Whether the e-way bill was valid.
That, my lord, that is to be considered.
That is the only thing. I am not deciding this.
I'll request, my lord, at this juncture, my lord may not go into that issue. Kindly keep all the issues open.
No, that part has to be there.
Because my lord, I am bound by my instruction. My difficulty is whatever I have been instructed, my lord, I have placed that before my lord.
If I had called upon you
Yes, ma'am.
So that's why I've recorded.
Malad,
Mr. Chakraborty would also submit that in terms of the direction passed by this court on 30th April 2025, he has been able to ascertain on instructions that the e-way bill, that the e-way bill for movement of goods as generated by the petitioner was valid at the time of detention.
Malad, kindly don't.
No, you are required to ascertain this. If you have not ascertained this and come back
Malad,
and tell me this.
Malad, I have handed over.
If
the
it is
request.
not, I will record it is not.
No, that's why I request, Malad, kindly keep this issue open. Whether at
No, I have ascertained this. I have.
that is the issue for the appellate order. But they have now come, they will file an appeal. All the papers have been given because that is the issue to be decided by the appellate.
Then I'll record that you are not been able to ascertain.
Yes, Malad, kindly record. Kindly, Malad,
Page
keep this.
16, my lord, I have annexed the e-way bill.
Keep the issue open, Malad. I request, Malad. I am beseeching, Malad, because their primary prayer was to file an appeal. Malad, all the papers have been handed over.
Not only that, it was a primary prayer.
Well, that was the primary prayer because this, once I submit something, this will be a decision before the.
No, whether the e-way bill, what remains in the matter, Mr.
But that is what I don't want.
And my lord, I am not on the entire penalty. I am on the proportionate penalty which has been imposed on me.
Only proportionate only, not entirety.
The difficulty was, there was a practical difficulty.
একটা লাইন প্যারাগ্রাফ লেখো আর প্র্যাকটিক্যাল শুনতে হবে না মিস্টার চক্রবর্তী would however submit that though by order dated 30th April 2025 this court had directed the respondents to ascertain whether the e-way bill for movement of goods generated by the petitioner at the time of detention of the vehicle in question was valid.
Page 18, my.
Would submit that the aforesaid issue be best left to the appellate authority to decide. He submits that the aforesaid issue be best left for the appellate authority to decide. Since Mr. Chakraborty, page
16, my lord.
Since Mr. Chakraborty could not dispute the document as appearing at page number 16 of the writ petition, I am of the view that the appellate authority, while deciding the matter, should consider the aforesaid document. Who should consider the aforesaid document. Rest of the order was passed yesterday. These are substitute only. I dictated that, but still then since you are not there, that's why I indicated Mr. Siddiqui was here, but since it is your submission.
I tended apology.
No, it's all right. You are busy with arbitration matters, so. Issue do, Mr. Chakra.
1 or 2 matters in a month, my lord, that possibly doesn't qualify as busy.
Very well, I'll call the list.
Number 3.
ঠিক আছে ঠিক আছে 2 মেনশন আছে না তাহলে এবার এই ডাকো 2 PM ডাকো
Item number 5.
3 here.
2 p.m.
Yes, 2 PM matters. Yes. Yes.
My lord, then 3 and 4 will be taken about 13th, Lordship. Then
Yes.
3 and 4 then can be taken up on 13th, Lordship.
Why after this matter? 3 and 4 হবে এরপরে Yes. You don't want to do the matter. Who's for the petitioner? 3 and 4? He does not want to do the matter.
I think it's a good date.
No, difficulty is if you are not there on that date, I'll pass ex parte orders because on 2 previous occasions for your absence, matter was had to be adjourned. Yes. Yes,
May I first
I
comply
have
my lord's order?
seen the order.
Yes. The entire records and short affidavit is here, my lord, to show how, my lord, the date, the venue.
I'll stay this and I'll file opposition reply. If you want to bring it by way of an affidavit, then I'll.
No, my lord's direction was there to produce the record.
Yes, affidavit is there
Yes.
on the
And also
notice,
short
only on the
affidavit.
note, only on the notice. Only on the notice, how we have published it.
Yes. All records are here.
I have what records how they have published it. Even
My lord, before
from the date on which.
Have you served him with a copy?
No.
Serve it.
there was no direction, my lord, I'm giving.
So,
I'm giving. But lordship kindly hear it is very important issue. Very important in the sense, writ petition has been filed, my lord, in the month of September, when there was no cause of action.
There was cause of action because they were not holding.
Now the notification has been published on 1st April 25. And this writ petition has been
I have
filed.
recorded, Mr. Nayak, have you read the order? I have recorded this.
That is
I have said that once you took steps, the matter ought to have rested there. But since after publication of the schedule, you suo motu again changed it.
I am explaining that.
So that is why
That I'm
he has now, I am taking up the matter. Otherwise, I would have dismissed the bit, not dismissed, I have
No.
disposed it off.
When my election is in process, my lord, now our High Court and also my lord's order and also Supreme Court has said repeatedly, I am placing it
Yes.
not to touch it. If it
That does not necessarily mean, sir, you will do whatever
if
you
there
like.
is something
Just show me.
I am showing lordship.
Yes.
Before that, lordship, my lord,
Why are you changing it all on a sudden?
that is required. That is required because kindly, my lord, takes up all this affidavit what I have given. This is on record. Record I am placing.
Yes.
Not that anything, my lord, prepared. The evidence has been prepared. One day
Yes.
we got this time. Now, my lord, kindly see page 9. Page 9. Here, my lord, 175.
When is the date of election?
First, my lord, 11th
11th of this month. Of
11th
this
of
month.
May. 11th of May.
Yes.
Now, my lord, the notification has been announced, published on 1st of April. April 25. And giving a lot of dates. This date petition is arriving on September. I do not know how he had, that day, my lord, it was suppressed.
Come to you, explain
I am
directly.
coming, lordship.
That part is over. I have passed that order already.
That was suppressed. I am also I feel, my lord, guilty because that
Mr. Nayak, show me your basis for change.
Now, my lord, here in this, my lord, particular ARCS, who is the RO, he has been intimated by, my lord, requested by, my lord, this 179 persons representation here making, my lord, 179.
How many members are there?
My lord, around 735.
780 members are there.
Now, my lord, initially, after publication has been, election publication has been made, my lord, on 1st April. Then, my lord, this representation came on my lord, 8th. On 9th, my lord, ARCS, the RO forwarded to RO, returning officer. Then after returning officer, my lord, sought opinion from the election commission. Election commission said since so many people are making this prayer and that is convenient, your place is convenient nearer to the center, nearer to the, my lord, registered office of the society. So maybe shifted. Because earlier center was 3 kilometers away, and the center now placed is, my lord, 600 meter
from
the main society center registered office. From registered office earlier was 3 kilometer. Now, my lord, it's about 60, my lord, 600.
Why did you fix it at that particular location? At the very first
that is
instance?
available, my lord. That school is available.
You did not comply with the order passed by this court. You sat tight over the order passed by the. Yes.
Forgetting election. Election
You
was
sat
over.
tight over Justice Manta's order. You did not comply.
My lord, it was not started. It was due to some reason. That was
What
not
was the reason?
My lord, that reason I will have to ask for because I have taken instruction as per my lord's objection.
No, that is also an issue.
Not in this writ petition.
Yes, certainly, in the writ petition, he has questioned your failure to not act on the basis of an order passed by a coordinate bench of this court. That is recorded by my.
In this writ petition, that means the election will not be conducted now. That's his prayer. How they are
Mr. Nayak, you answered the court. A.
I'm telling
Only on the basis of a representation you changed. And why did you fix it at the first instance to another location? Why did you fix it? What was the basis of fixing? I directed you to produce the records. Where are the records? No, all the records.
Yes.
All records.
These are all the records.
No, these are not, cannot be the records.
If I'm referring, if my lord is not happy, give some direction, certainly we shall do, but we don't have any other record.
Election is fixed on 11th.
11th of May.
I directed you to produce the records. You did not produce the records.
This is the record, Lordship.
There are records. What?
I'm saying.
How my lord is saying?
Where is your
Service of the notice. Service of the
I
notice.
have given it here. Service of notice, my lord, my petitioner is saying. he
No,
has
no,
not
you
been-
conduct it at the original place. I will not delay. You conduct it at the original place unless you are in a position to satisfy.
Lordship, let me complete.
Yes,
my lord,
yes.
let me have this chance. Now, my lord, he is saying.
All your notices that you have disclosed is after the publication.
Yes. Thereafter, the demand and problem came up. We cannot imagine any problem earlier. When problem came up to us, we'll have to take note of it. And what is
Why?
that?
Why did you not
That is the
contemplate
system,
this?
Lord,
Why did you not contemplate this previously? And where was the previous election held? Why was this venue chosen by you at the first instance?
This is the place where I am saying, Lord, conveniently, this is the place where election is being held. That is on affidavit I am saying, Lord, I cannot stop my own.
Wait. Come to page number 19, Mr. Nayak.
Yes. 19, Lord, this is
And tell
the,
me where is the venue?
and Lord, this is a notification.
Where is the venue?
Venue is Milord, Gongura Mohildar City, Mohaldar City Prathamik Vidyalaya. This is the Milord corrigendum.
Where is it?
That was dated 21st of
1st April 2025.
21st April.
Where is the venue written? Which line? Which line is the venue?
1st April notification, Lord, you kindly see Milord there. That
1st April notification was completely different.
Kindly take a bit. That is there, Milord, page 19. 19
Yes,
of the
yes.
supplementary affidavit.
Yes.
It is there. It is in Milord.
Which line, Mr. Kindly tell me.
Rajipur Prathamik Vidyalaya.
Where are you reading it? Where are you?
Page 19 of the supplementary affidavit.
No, I understand. Which line? Which portion it is there?
Program is there, Milord, everywhere in the bottom portion.
Oh, acha. Raji, I got it.
Date
This is
of
Rajipur Prathamik Vidyalaya.
That was the date of venue of the election.
Where is this Rajipur Prathamik Vidyalaya in Raj?
That is 3 kilometers away from the society registered office. And this is.
So why did you fix this venue?
That was, Milord, the suggestion, or Milord, initially it was. Why, Milord, I cannot say it now.
Why is it changed now?
Now, because of this demand and problem.
No. Why did you fix it there and why did you change it? You have to act rationally. You have to act rationally.
No.
You cannot.
I'm giving example, Lordship.
Yes.
Similar circumstances arose in Milord Kontai, Milord, cooperative elections matter.
Yes.
All the venues were decided by Milord the commission. Then Milord the all program nomination.
You cannot have absolute right to change the venue.
No demand, no absolute right. It is the observation of Milord.
Show me the your decision on this. Where is your, which page is the decision?
This, Milord, since it has been referred to.
Yes, which page?
Page 19, Milord, of
19. Yes.
This is the Milord corrigendum notification. Now this has been served to everybody.
How?
No, it has not been served.
I am telling you.
How it has been served?
I have on affidavit. I am saying to Milord courier or by post. I have said I on.
Where are these couriers? Where are these couriers?
You I have given.
My lord, I have at least brought
not in both
200 surveys.
No,
all are.
You cannot serve. Kindly wait.
But petitioner said that he has not been served. He has suppressed it. Kindly come.
Show me, she has been served.
Yes, he has been. He has received it of his own.
Show me.
Yes, we have received it, but when?
You have said you have not been intimated.
We have been
Now
not on 21st,
Kindly come
not
to page-
on 21st,
page
not on
20.
22nd, but on 27th.
This is suppression. They're again trying to justify.
Yes.
Page 26, Lordship, come. I have given some this corrigendum notification received by everybody.
Page 26, you have received it. Very well.
But he is saying it has not.
Very well, he has
He
received.
doesn't know. So in suppression,
How many petitioners are there?
Milord,
Two
here
petitioners
two
are
petitioners,
Two.
each one of
Where
them.
is Tarok? Where is Tarok? Tarok?
Another Milord, I could not locate yesterday night.
We have
But I am told on affidavit that it has been Milord in the letter also I have said. Milord, kindly come to the report of the RO. Lord, so kindly come to page 29. There's the report of the RO. He is the main person.
Yes, my lord, it has not been sent. 28 to 28-4. I am sending my lord answer. I'll give
Please,
copy.
please, sir.
He has been given on 28.
Yes, very well.
So suppression, he is saying it has
28,
not been
suppression.
intimated.
It is not.
My confirmed news is miking is there. In conspicuous place, it has been
Miking and no.
very well. No, it is not
It-
modality also. It has been served everybody, number one. And number two, paper notification has been made.
What is
Local
your
paper.
objection to this place?
No, kindly come to
My
Milord.
lord,
please.
I've got it. It's missing.
my lord, our objection in that case, I have to say who are the persons who have applied. I didn't want to open the lead, but the lead is, I can't say it is open court.
Why?
Something of completely political and communal nature.
Where is this place? Where is being shifted?
This place
600
has been,
meters.
this
Society said.
this place,
I on affidavit have said so.
this place is near the office of this society, not 600 meters, but there is a school. But why I don't know why more than 600 members have been asked to travel 3 kilometers away, 4 kilometers away, and to cast vote only because some members or non-members have made an application to the cooperative election.
They are
Commission.
non-members.
Some members are there. We have to check it up. Maybe some members are there, but who are they? What is the
That's
member
the
number?
issue. First
Sanajul,
suppression.
my
We have
lord,
said
say
we have not been intimated.
Sanajul Sheikh. I have got.
We had to take Milord huge problem
he will
yesterday.
not allow me
because
to
all
speak.
officers-
Kindly read your resolution. Where is your decision to change?
This is the resolution, Lordship.
Yes, kindly read it. It's illegible document has
My
been
Lord,
placed before
next
this.
page,
court.
Lordship, the same thing.
Which page? Which is a better copy?
20, Milord, 20. All of the same.
No,
notified, everybody
none of
is-
these pages can be read.
Milord, 21, then kindly
No,
check.
same thing. 22 is little better. You place it.
21, Lordship.
You
I'm
place it. You place it.
reading it, 21. এত
22. Place it is better.
22 I am reading.
Yes.
22 এত দ্বারা পলিসির সমবায় কৃষি উন্নয়ন সমিতি লিমিটেডের সকল সদস্যগণকে জানানো হইতেছে যে আগামী 11/5/25 তারিখ রবিবার সকাল 10:30 একটি বিশেষ সাধারণ সভা রাজীবপুর প্রাথমিক বিদ্যালয়ে অনুষ্ঠিত হওয়ার কথা ছিল, কিন্তু বিশেষ সাধারণ সভা পূর্বের নোটিশ অনুসরণ করে একই সময় 10:30 এবং একই তারিখে 11/5/25 তারিখে রাজীবপুর প্রাথমিক বিদ্যালয়ের পরিবর্তে গোংড়া মহিষদার স্মৃতি প্রাথমিক বিদ্যালয়ে অনুষ্ঠিত হবে। সেখানে ভোট গ্রহণ, ভোট গণনা এবং ফল ঘোষণা
No,
করা
there
হবে।
is no reason disclosed here.
No reason.
My Lord, can I see? উল্লেখ থাকে
No reason disclosed.
no region is required to be given. That's the observation of our division
Show
bench.
me-
I'm
show
showing
me
it
the
to
division
Lords.
bench. Show
I'm
me.
showing it to Lords. No region need to be given. I'm showing to Lords. Election Commission, my Lord, they are holding election. They are not bound to give all reasons why all steps have been taken. And any voter is having no right to know this.
No right to know. A voter is a stakeholder. He does not have a right to
that is
know.
the observation
Why
of
will
the
you
division
change
bench.
it? Show me.
I'm showing it.
Show me.
Kindly have
That
a-
is about
have a look
fixing
to
the
this
first
Milord
one, not
division bench
changing.
order. No, I'm showing this is the exactly
It was fixed,
observation has been made.
the other judgment which I consider and allowed in your favor. This is point that
No, Milord, kindly.
yes, Justice Shomada's judgment.
Kindly,
Yes,
kindly,
yes.
kindly give it to me. Some written is there.
Place it,
Milord.
place it,
No,
place it, please.
This one, take it. Joshua Sote niye asun. I'm sorry, Milord, there is some right of my own in that.
फिर दियो,
Please.
Doesn't matter.
No, I know that, Milord, even that.
No, that part will not matter, Mr. Nayak.
Milord, may I place it?
Yes.
Now, Milord, kindly come to page 2. From 2, I am placing this required to be Milord placed. The fact is similar. Essentially, second paragraph. Section, the Election Commission is aggrieved by the decision rendered by the learned single judge, whereby notice dated 7th February 17, issued by the Assistant Returning Officer, shifting the venue of holding election of the concerned cooperative society from factory premises to an educational institution, namely Damdam Kumar Asutosh Institution, main for boys, was set aside on the ground that the Assistant Returning Officer did not assign any reason as to why the venue was required to be shifted. Now, from the ground set out in the memorandum of appeal, it appears that the change of venue from inside the factory premises to a place outside was only for the purpose of securing neutrality and fairness and election of the cooperative society concerned. From the judgment and order impugned, however, it appears that on behalf of the petitioner, it was contended that it was the custom and convention of the society that election of the cooperative society would be held at the factory premises. It was submitted on behalf of the petitioner before the learned single judge that said 1921 election of the cooperative society had been held in the factory premises. The court, upon considering the respective contentions of the parties, expressed surprise as to how and in which manner the Assistant Returning Officer decided to change the existing venue from the factory premises to the educational institution without assigning any reason. The question that falls for consideration, therefore, is whether reason has to be mandatorily assigned by the assistant returning officer for shifting of the venue for holding election of the concerned cooperative society. In order to find an answer to above question, it is necessary at first to avoid Article 243 ZK of the Constitution of India, relevant here in clause 2 of the Article 243 ZK, which reads as follows. The superintendent's direction and control of the preparation of the electoral roll for and the conduct of all elections to a cooperative society shall vest in such an authority or body as may be provided by the legislature or a state by law, provided that the legislature of the state may by law provide for the procedure and guidelines for the conduct of such election. A plain reading of the above reveals that not only superintendent's direction and control of the preparation of the electoral roll, but the conduct of all elections to a cooperative society vests in such an authority or body as may be provided by the legislature of a state or bylaws. It also provides for the legislature for a state to enact laws to provide for the procedure and guidelines for the conduct of the election. Section 96 of the Cooperative West Bengal Cooperative Society Act 2006 relates to constitution of a cooperative election commission.
He is evaluated, but this court does not say that he has unfettered power to change the venue. I've read it. He said that they are not required to provide reasons. I've read it, page 6.
In terms of yes.
But that gives you unfettered power.
Yes, Lord, I am also saying, Lordship, Lord, I am trying to Lord, give some also Lord, support, assistance Lord, for
My lord, in this case, the
next
demand
thing, Lord,
was that usually, I was there. In that case, it was the demand that usually the factory premises in the elections were held, so that should not be shifted elsewhere. So first notice was not given in the question.
Where have you said, Mr. Bhattacharya, the allegation
without the power of
wait, kindly wait. Mr. Bhattacharya, the allegation you are trying to make today that due to communal reasons or due to other reasons which are not apparent from this, venue was shifted. Where is your allegation to that effect? In the supplementary affidavit, have you disclosed the fact by a supplementary affidavit?
Lord, nothing is there.
Let me find out.
Yes.
One, two more things, Lord, may I
Let me
please?
find out.
Supplementary.
You have filed a CAN application?
Yes.
Yes. Where have you said in the CAN
And this is
application?
the Commissioner Cooperative Election Commission.
Yes.
আমরা নিম্ন স্বাক্ষরকারীগণ পল্লীশ্রী সমবায় সমিতির সদস্যগণ এই বলছি এই ইউ আর ওয়ান
Which page?
মাই পেজ 20 দিনক্ষণ ধার্য করে রাজীবপুর গ্রামে নির্বাচন
How many persons have filed this?
Around 300. After that, after 21st corrigendum notification,
after this
the
notification,
moment corrigendum
yes,
notification came,
around
then my lord,
337.
representation came up.
337.
After thought action.
Not after thought action.
Yes, corrigendum notification has been given.
He will not allow me to answer my lord's question.
It's April to my lord 22nd.
He will not answer. He will not
Then
allow.
corrigendum notification.
Exactly.
You have given a response and said that by reasons of difficulty faced by 139 persons, you have changed the venue.
No. Other two reasons are there. Lord.
Where?
Shorted. Below, it is a below shortest.
That you have submitted. That you have submitted in court.
I've given it. And one
Yes.
more reason.
Tell me what is the other reason?
Other reason, my lord, the distance is very shorter distance. Is nearer to my lord.
That was also available to you at the first instance. That was available to you at the first instance.
On the guidance of the society, my lord, law says initial stage. My lord, with the guidance of the society, my lord, either special officer or nominated board, elected board, my lord, it will be decided. They might have suggested it. Later on, demand came and my lord, application of my
lord, there was
What is
no
your
board.
legal challenge to this, sir, Mr. Bhattacharya?
My lord, how
Mr.
they will ask
Nayak,
the
kindly
same
take your
question.
seat.
How
You have
am I?
disclosed all your documents.
My lord, first of all, the
Yes.
Cooperative Election Commission has not been given any power to change the venue of election unless something happens, unless there is flood, unless there is natural calamity, something like that, because some persons have made an application of one village. So it has been changed. My second point, my lord, the election shall be synchronized with the annual general meeting. The Cooperative Election Commission has not been given power to convene annual general meeting. That has to be convened by the registrar. And under section, kindly allow me, why it is not, my lord, it's not possible for me to
After
say.
the regulation come into force, As per section
The
96.
regulation does
we are
not
to-
give any
we are-
power to the authority,
We have
to
to
the,
go by the
to
election
the
Commission
Cooperative
regulation,
Election
not
Commission
the
to
rules.
change. Yes, you have been asked to, you have been authorized to hold
Rule
election in
cannot be-
accordance with the
cannot be
rules.
read at all,
In
cannot be
accordance,
referred to.
not rule, but section.
Cannot
Yours
be
is,
referred to.
yours is a, I should say, is a prepared by the Cooperative Election Commission.
It has
But
not
what
been
the,
challenged.
what the law says, I'm saying, what the law says, section 30. So I'm coming to
Regulation
that.
comes into force.
No.
Election to be conducted by the regulation only.
My lord,
All rules
if
and
it doesn't allow me to
laws
speak,
will
how
be
can I
given
say?
by- I'm reading it, Lordship.
No, I'm reading. Let me say my book.
You are
Let me
misquoting,
say
my
I'm
lord.
not misquoting.
You
What is
are.
the
I'm coming
regulation?
to your place. Yes, my lord.
Lordship kindly says.
No, I'm coming.
Kindly come to 96, section 96, Lordship.
Section 94.
Both of you, Mr. Nayak, you are quite. Both of you, are you please, Mr. Bhattacharya is there.
Time.
Both
No,
of you
I'm
start
not taking
together.
time.
I will hear both of you.
I'm not
I will
taking time.
hear both of you.
My lord, may kindly see.
Very well, let him
Section
complete.
96. I'm
Let
letting
me conclude. Thereafter, I
Let
hear
me
you. Then pass
complete.
it.
Let me complete. My lord.
Section.
98.
Yes.
96. The
Yes.
Cooperative Election Commission state shall constitute a Cooperative Election Commission and appoint such and such persons, etc. This is not subject to the provisions of this. Kindly come to 96.8. Subject to the provisions of the Act, the Cooperative Election Commission shall make rules, regulations, and procedures.
Which 96? 8.
8. The Cooperative Election Commission shall make rules, regulations, and procedure providing for the conduct of election, pattern of preparation of electoral roll, fixing the date, place, and manner of election, fixing date and manner of publication and declaration of the results of election, fixing the cost of holding election of a cooperative society, and fixing of assessing the realization of such cost, symbols that may be used. Now, my lord, come to until the cooperative election is my lord, we come to rule. Come to 9 is until the cooperative election is constituted.
No, that is, kindly read that.
Until the Cooperative Election Commission is constituted and required regulations for conduction of cooperative societies are made, the government may by notification notifies the date with effect from which the election of all cooperative societies shall be conducted by the Cooperative Election Commission.
Yes,
then my lord may come to the rules.
Rules.
But rule is not applicable.
Why not rule is not? Rule is definitely applicable because subject to the acts and rules you will do.
Yes.
My lord, come to a section. I am also quoting another section. Section 29.
Annual general meeting, sir.
Or that annual general meeting. Kindly don't interrupt me. You will have time. You will have time. Annual general meeting. Section 29. My lord may come to section 29(5). The agenda of annual general meeting shall be as follows. In the case of election of directors of the board shall be held before the Term of Commission Services Act within 3 years, any other. Election Commission provided further that after constitution of the Cooperative Election Commission, such election shall be held in annual general meeting or special general meeting held under the provisions of section 29 and 31. What it says, section 29, what it says.
Very well. I get you.
So there is no general meeting has been called. And if it is not called, how the notice can say that the general meeting, that is special general meeting that has been called, will be shifted to Gongla Mahaldar Cooperative Express?
It is a general meeting.
It is not general meeting. Your notice is not general meeting. General meeting has to be called. I'm showing
something.
Who has called Sadharan Sabha?
I'm sorry to interrupt.
My lord, he can't say.
It is Sadharan
He can call a general
Mr.
meeting.
Nayak,
Who
I
can
will.
call a general meeting? Let him
Please wait, Mr. Nayak.
Can call a general meeting.
You see,
doesn't
বিশেষ সাধারণ সভার notice. In my understanding, that is a special
General meeting notice.
general meeting notice.
Where is that notice? Who has called it? Who can call it?
The previous notice was also called by the assistant returning officer.
Assistant officer cannot call.
That is also there.
In the election notification.
The election notification.
1st April 2025, you are not aggrieved by that? Are you aggrieved by the notice issued on 1st April 2025?
Yes, I was aggrieved. I was aggrieved.
Then you ought to have been aggrieved by the order passed by His Lordship, the Honorable Justice Mantha.
That is because of my, that is, I should say, bovine contentment of my
You had appeared. Mr. Bhattacharya, I've seen your name. You had appeared. You have accepted this order.
I had accepted this order and I communicated to them to hold it.
So at that stage, there was non-compliance of section 29.
There was non-compliance of
Correct?
And yes.
So when there is a void, there cannot be compliance of section 29.
No, section 29 has to be complied. Otherwise, how can a meeting?
If there is no board.
If there is no board, a special officer has to be appointed by the registrar for calling. In other cases, it is being done. In Bhatpada, what they are doing, that is also with me.
Then this order has to be given a go by to. You ought to have preferred an appeal from this order.
From which order?
The order at page 11 of the writ petition. Order dated 19 November 2019.
No, that after that, it is necessary that synchronization should be there.
Assistant returning officer has been appointed.
Assistant returning officer cannot call annual general meeting. No such authority is there, even in the Cooperative Election Commission's notification.
Very well, I'll keep your matter pending. I'll hear it out.
Yes, my lord.
Well, late election be conducted.
Yes,
Result
yes.
will be awarded by the result of this. We have no objection. I am telling you, Lordship, we not want two more things. Lordship, it's under similar circumstances, our division bench of this
No,
court.
I'll not go into this. Yes, any other thing?
Yes. Kindly, my lord, read. Kindly, my lord, I'm referring paragraph 6.
He is trying to challenge such an
That's
issue.
not here and there, Lordship. Nothing is there. Kindly see, my lord, he is trying to stall the election. Paragraph 6. Similar
He
circumstances.
had made an application that you should do it.
Legal issue is not
Twice.
race integra, please. The earliest view with the decision of the Honorable Supreme Court number so wherein it has been held that once the election process starts, it would not be proper for the court to interfere with the election process. And similar view is also taken in the judgment of such and such and such and such and such. And the above decisions have been followed by Honorable Supreme Court in paragraph 16 of the decision of the such and such. And my lord, election was not at all touched at all, not under similar circumstances. And my lord, there are dead men saying, but a lot of problems were there. But I rely on this.
My lord, I am entitled to 21 days notice. Why it was not given to me?
Sir,
Let him show that they had given to me 21 days prior to the holding or shifting of the venue.
Sir, I have given the shifting no reason.
No. I have got. You have served it on 28th, 29th, 30th, 1st of May.
Pursuant to the order dated.
One more decision, my lord, on the issue.
I can 11 decisions are
Pursuant
there.
to the order dated. On the same heading in the month list of June 2025.
Can I submit an affidavit? My lord, one thing, I have not stated that. I have got what they were saying. Pen drive. I can show that even in the cooperative society, one of the first signatory.
Sir, what more do you want? Police assistance is there.
My lord, there is
You
police
cannot go and
standing
vote.
before the police standing.
You cannot go and vote.
The nominations given by my clients were torn aside.
If you
I
cannot go and vote in the presence of the police authorities in a particular
My lord,
place,
my lord,
he will not be in a position to also go and vote in another place.
yes, we cannot, because the entire administration is sidelined.
So let the assistant returning officer file a report before this court.
Nobody, but I have got, but
Yes, yes.
but everything has been recorded.
Aru will give.
But my
The returning officer shall, yes.
my
Returning
lord,
officer,
everything has been
the
recorded. I can
returning
show.
officer, including the assistant returning officer.
I may be allowed.
When returning officer comes in, ARO has got no weight. No,
Both.
RO is in charge, Lordship.
My lord, I may be permitted to mention this in my reply that
The petitioner shall be at liberty to use a supplementary affidavit to deal with.
stating
Permitted to use an affidavit in reply to deal with the report and file of shall be at liberty to file an exception.
Will
Invited to file an exception to the report filed on behalf of the Election Commission, West Bengal Election Commission, on or before the matter is taken up next with an advance copy thereof to the learned advocate representing the election.
I will not record that the
my lord,
report which
Nothing more.
I may be
that has
permitted.
been handed over. That has been handed over to petitioner. It has been handed over to petitioner also. Kindly
No,
record it.
no,
Otherwise,
Mr. Bhattacharya will not deny.
my lord,
He
nothing.
may be a loggerheads in a matter,
Not
but but he will not deny a factual aspect.
why should he? Why should
But
he?
it is
When
mine.
it should be
It is
changed
not
because
mine, my lord,
179
nothing
persons
good
are
to say.
in
Very
of
well.
one community.
এগুলোকে ঢুকিয়ে দাও অর্ডারটার মধ্যে ঢুকিয়ে দাও।
Because one,
Yes, call the next matter.
I am told
the
my lord,
first person signing
election-
there, he was.
some
I
recording
told-
perhaps my lord, instead of 25
Is not the date still then are taken up considering the urgency.
Item number 3. Instead of 25, it has been perhaps 24 has been recorded.
I'll correct it.
Lords, I'm grateful, Lords.
Election will go on.
My lord, no, date. 11th of May 25. It has been written, my lord, I am told 11th of May
I'll correct it.
24.
I'll upload it today.
Lords,
May I use an affidavit?
Yes,
How we have
exception.
been tortured and how our nominations were. Why not? Why not? We have got recorded.
Yes, call the next matter.
Item number 3.
I will, or not baseless allegations. These are there.
Grateful, Lords. Grateful.
Okay, one more line. The pendency of the writ petition will not impinge upon the rights of the petitioner to raise an election dispute after publication of the result if the petitioner so
Even
chooses.
the Cooperative Election Commission has got no legal right to hold to.
Very
Everywhere, in every point, in every step.
The law does not give them the right.
Sir, what a-
Yes, call the next matter. Yes, AN instruments. Who's appearing?
I am appearing, Lordship.
Yes.
This is a service tax matter, Lordship.
A pendency of the writ petition shall not impinge upon the petitioner's rights to raise a election dispute after results of the election are declared. No, impinge upon the rights. খালি হলো।
In this matter, Lordship, the order in original was passed in the year 2016. An appeal was preferred and the appellate authority remanded the matter back to the adjudicating authority for fresh adjudication after giving opportunity of hearing to me. And it was appellate order was passed on 22nd May 2018. And in 2023, the first notice of hearing was communicated to me. In the year 2023, the first notice of hearing was communicated to me, but it was communicated after the date of hearing.
After
the date of hearing. After the date of hearing. So I could not participate. I immediately communicated.
Expiry order was passed.
No order was passed. I immediately communicated that the letter has been served belatedly, so I could not participate. A fresh date of hearing may be allotted to me. Similarly, 5 notices were issued and all came to my premises belatedly. So I could not appear. And dispute is regarding 6th and 7th notice. 6th notice I never received.
A 7 notice was served, but it was served also belatedly. And after the 7 notice,
You are saying that Mr. Banerjee's client is playing hide and seek with you.
not hide and seek.
No. Is it your case that they are playing hide and seek with you?
I can't say that, but it may be the department is not so much concerned.
Mr. Banerjee, how many notices are admittedly outside the time? Tell me that. How many notices?
First 5 is admittedly also.
5 admitted.
Admitted. In the order it has been admitted.
Petitioner cannot admit by.
No, in the order if it has been admitted as an admitted.
Page 56, kindly.
Admitted.
Rather, he admits that he gets the electronic mail.
No.
Let's come to page 56.
Page 56.
In response to your above notice for hearing served upon us, we are hereby
Page
drawn your-
56.
56, Chappan. State that we are hereby informed by our learned advocate that the notice of the hearing of the aforesaid proceedings are also being communicated through electronic mail as well as through the speed post, as the speed post consigned not reached before the date of hearing. So we could not face difficulty to attend. Now electronic mail and deactivated and we are permanent. First he said that is received. The any moment he received in the electronic mail, he deactivates. Then he gives me another. His intention is so that I cannot do it within my time. And after a certain
How many?
time,
What was the time limit for you?
I passed it within the time. 2 years.
What was the time limit?
2 years was the time from the date of initiation. It was remanded back. So I will get that exemption of the time. I passed it within time.
After remand,
Now
they waited for 5 years.
That's what they said. And I found every time he has made
2 years is the time limit.
from the initiation.
Then
Moment I issue a show cause notice, I have to pass the order in original within time. So now that is
it was set aside.
I passed it within time. He has gone to appeal, set aside, remanded.
So after that, how many years passed?
After that, within the time I have done.
Within 2 years.
Remanded back to me within 2 years I have
When is that?
done. Lordship, kindly see. The first order has to be passed within 2 years and thereafter it depends.
Anything.
Sometime it goes up to Supreme Court, then remanded back to me. So then the limitation will not.
No, from the date of remand.
No, there is no time limit for the date of remand. From the date of first issuance and first order in original.
Where is that?
Lordship, kindly come to the
Okay.
order in original. Page 116. Page 61.
Which provision mandates you to pass an order in original within 2 years? CGST.
GST active.
Which provision? So it's Service Act, Service Tax.
No. GST.
GST. Yes. ওটা নতুন এখানে আছে ঠিক আছে জিএসটি আছে yes
Oh.
Means which provision mandates you?
Lordship, that might not be.
Order was passed before
Hey,
the
wait.
date of GST Act.
You will make submissions. When Mr. Banerjee is submitting, please sit down. Take your seat. Ask your juniors to take your seat. Yes.
Service tax to bear.
So I wanted to see the service tax. You want me to go through the GST?
Time limit.
Yes, which provision?
There is a time limit, Lordship. I'm Achhi, query.
Yes, Mr. Barman, which provision? Both of you have come to argue, you are not aware.
73 4B.
73 4B.
Subsection 4B. One year.
1 year.
Case 6 months, otherwise 1 year but 6.
So bad.
Service tax.
Service tax 73 4.
That's one.
Custom 2 years.
73 4B.
4B.
Yes. Within 1 year, very clear. So if it is applicable for the original order, so that date of demand, from the date of demand, you are also required to pass it within 1 year. Unless you say that it is not necessary to do so.
That is the original order which has been.
Then what is the object of the statute providing for the time limit? Only for the sake of enabling the authorities to for the first time. Thereafter, what happens is not concerned.
Remand order cannot be equated with the show cause. Remand order, if your lordship goes
Let
by
me
that
see the order.
interpretation-
Let me see the order. It's a is it
That's
a,
not his case. In this case, his case is he.
let me
did
find
not-
the order. Where is the demand? Where is the demand?
Order on demand.
In order to that.
Page 61.
Which page?
61. Page 61.
Yes. How was it remanded back?
That lordship will get at page.
Page number 46. Page number 46, the order passed by the appellate authority.
Para 8.
Which page?
Page 50, para 8.
Yes. Kindly come to the last paragraph. Kindly place it. In view of the findings of facts of the case and in terms of the provisions made in section 74 3B,
Yes. Lordship kindly read.
I remand the matter.
70. Yes. Lordship kindly let me place 74.
Yes.
Ah, 70. What 3B? What 3B? Lordship को थोड़ा सुनो. 3B. तो
B. It is 4B actually.
– 74 3B. Yes. Lordship. Those two provisions are different.
Yes.
Lordship, these are not his case, Lordship. His case is he did not receive notices after remand before passing of order in origin. That's his case. So only thing I have to show that he.
This was a decision required to be taken under section 73. 2.
Service tax Central officer considering the representation made by a person by whom the notice is served on determine the due from refund to say and now they pay the amount so determine.
An order under section 73(2) was required to be passed under section 73(4)
3B.
A within 6 months from the date of notice where it is possible to do so. In respect of cases falling under subsection 1, it is not under 1. So it is under 2. So 74 4B B. No. Central shall determine the amount of the service tax due under the subsection 2 within 1 year. Now, subsection 2, if your lordship kindly see, this is subsection 2.
Yes,
Your determination order is originally subsection 2. Come to page 61. Your order in original is there. Lordship is equating the remand order with the order in original. I'm saying that is not possible. Once the order in original is there, then the limitation is there, those factors are there. Original show cause notice is of 15th of October 2015. Right. How long can you stretch that? No. I passed the order 2016. Correct. Then it has gone to the appeal. Correct. The appeal court remanded it back. Then it remanded back to me. Then you again decided it. I decided. Now his point is. He again preferred an appeal. No. Now he is saying that he is of natural justice. He is not in appeal. He says, I did not get the notice properly. That is all he is saying. He does not challenge this issue. No. That is not his issue because this issue is a substantial issue. He has to go for appeal. Which issue? Whether the order is time barred or not. He cannot take it in judicial review. What are you saying? He can. If lordship allows, he can. Otherwise, what do you say? I want to ascertain from you whether it is within time or not. No, that's all right. But lordship, his challenge. Yes, come back. Come ready on the next date with all the provisions, Mr. Banerjee. I will. But this here he only said if the notice not received. But I have shown from his own document that he acknowledged the norm. Heard the advocates for the parties. Let this matter be taken up for further consideration under the same heading. Next Thursday date দিয়ে দাও হোক না হোক দেখা যাবে ডেটটা এই Thursday. Now, Lordship, I have a small request. Item number 4, the similar another matter is also running in the list. Sure is here. Sure is. So, Lordship, both the two matter can be taken up. Because these are two different matters. No, same matter. Same matter, similar issue out of same issue here. Not this one, Your Lordship. Item number 4. No, I can't take it up. No.
Lordship, just let it remain in the list as it
Yes. They will remain in the list.
is. The next two matters, so it will follow.
Yes. জন্য বলতে গেলাম তোরা না বললি না দরকার ওদেরই তো জন্য বলতে গেলাম দুটো ম্যাটার একসঙ্গে